Regulatory powers of traffic commissioners. Being called to a public inquiry for the first time is a daunting experience for most operators, and in some cases it's hardly surprising because if things don't go well, it could lead to a loss of operator license and in consequence the loss of ability to trade. In this presentation we look very briefly at the regulatory actions available to traffic commissioners. This is a very general overview. You will find a great deal more information in statutory document number 10, the principles of decision making and the concept of proportionality. I know that's a bit of a mouthful. This is why hopefully you'll find this short summary of use. Traffic commissioners have regulatory powers, including the power to curtail, suspend or revoke a license. A formal warning is not a direction within the terms of the legislation, but if a formal warning is ignored, it will be a factor to be taken into account at a future public inquiry. Often at public inquiries we conduct, the Traffic Commissioner doesn't take regulatory action but issues a formal warning. That usually is regarded as a good outcome. Curtailment involves the reduction of the number of vehicles permitted to operate. This could have implications for a business, particularly if the business is seasonal and all vehicles need to be operated, and any curtailment is obviously going to have a direct bearing on the efficiency of that business and its ability to service its customers. A suspension means that vehicles are unable to operate for a period of time decided by the Traffic Commissioner. A revocation means a loss of the license. This is the most draconian outcome. If the license is revoked, the Traffic Commissioner can also disqualify the license holder from holding an operator license either indefinitely or for a period of time, as the Traffic Commissioner sees fit. Traffic Commissioners may, as a starting point for a first public inquiry, give consideration to a disqualification period of between 1 and 3 years. Serious cases where, for example, the operator deliberately puts life at risk or knowingly operates unsafe vehicles or allows drivers to falsify records may merit disqualification of between 5 to 10 years and in some cases for an indefinite period. When making a decision, a balancing exercise is conducted by the Traffic Commissioner to weigh up the relevant positives and the negatives. A preliminary question is considered: how likely is it that this operator will in future operate in compliance with the operator licensing regime? Balancing all these matters against the consequences of losing the license, Traffic Commissioners have to conclude what is proportionate. If, based on the evidence, the answer to that question indicates a low probability of future compliance, then it supports a conclusion that the operator ought to be stopped from operating, even if that means the operator is put out of business. If the evidence shows the operator is likely to be compliant in the future, then it supports the conclusion that the operator should not be put out of business and the license allowed to continue, perhaps subject to a suspension or a curtailment or the issuing of a formal warning. In making their decision, Traffic Commissioners will consider the steps that have been taken by the operator in advance of the public inquiry. Traffic Commissioners typically classify operators into one of 4 categories. The first category is those who recognise problems and shortcomings early on, for example, following a fleet check or an adverse roadside encounter, and immediately take steps to rectify the situation. This is regarded as more proactive than reactive, and this category of operator is least likely to be subject to regulatory action. The second category is those who only recognise there is a problem when called to public inquiry, but put matters right before the public inquiry itself. This is regarded as being reactive rather than proactive, and also gives the impression that if it were not for the public inquiry, no steps would have been taken. This may lead the Traffic Commissioner to consider undertakings or perhaps some form of regulatory action, such as curtailment or a suspension, simply because they're not sure whether this operator is going to be compliant going forwards. And they want to put a marker down simply to impress upon the operator the consequences of not being compliant. The third category are operators who recognise the issues that need fixing, but appear at the public inquiry with a plan of action and a promise to implement it. This category of operator can expect some form of regulatory action. The fourth category are operators who bury their heads in the sand, do absolutely nothing, and wait to be told what to do at the public inquiry. This category of operator is likely to be the subject of regulatory action. Most operators called to public inquiry will sit somewhere between the second and fourth categories. The operators most likely to receive a formal warning only are those falling within the first category. Actions speak louder than words. But also those operators who, after being called to public inquiry, take positive steps to place themselves within the second category. We hope this short presentation has been helpful. Please like this presentation or leave your comments. Please subscribe to this channel and encourage your drivers and managers to do likewise. When you subscribe, you are automatically alerted when we add new presentations to our channel. It may well be that if you were ever called to a public inquiry, you might want to make reference to this subscription as evidence of the proactive steps you took to ensure compliance with your operator license undertakings.